Call this meeting of the Police Oversight Commission back to order. We move to the Independent Review Officer's report.
And finally, I wanted to discuss the cease and desist letter that the Albuquerque Police Officers Association has sent to me in my response to it. In response to the letter I received on November the 27th from the union, I reviewed the letter, the law, the contract, and made an independent decision that I would conform or comply with the request, if not demand, from the Albuquerque Police Officers Association to modify the way that fully investigated CPCs are presented to the commission and modify my presentation to conform with the contract which was entered into between the city and the Police Officers Association. I believe that it's my job to enforce the rules and the law. I don't necessarily have to agree with the law, but must apply it. And the contract between the city and the union expired, but there is my reading of the law and of the other pending litigation is that the contract, the effects of the contract remain in effect, both by common law in that the union has a reliance upon the contract and that a party unilaterally can't modify a contract which has been honored. And in addition, there's pending litigation. There's litigation which has been decided that would indicate that the contract still has effects. So based on all of that, I came to the independent decision that it would be in the best interest of justice not to sustain a lawsuit from the union, but to conform to the contract as written. And so my letters, the first 3 CPCs which are on tonight's agenda, are letters that are in conformance in my belief with the union contract. Mr. Fred Maurer, the author of the letter and the attorney for the union, is here if you have any questions.
Okay. Are there questions of Ms. Hammer or Mr. Maurer? Commissioner Shine.
Thank you, Mr. Chair. I'd just like to make a brief statement. I would like to register my objection to the IRO's decision and the position taken by the union's lawyer in sending this cease and desist letter. I believe that certain provisions of the collective bargaining agreement that restrict the information that the POC can obtain from the APD, including the provision that Ms. Hammer has just discussed and which is referred to in the letter, or those provisions that otherwise limit or infringe upon the authority of the POC as provided by the POC ordinance, are unlawful and unenforceable. I don't believe that the executive branch of the city government has the right or the authority to, in effect, amend the POC ordinance by negotiating the provisions of a labor agreement. However, because hopefully the work of the POC task force may soon lead to the City Council significantly amending the POC ordinance, attempting to independently litigate the issue at this time based upon the provisions of the current ordinance, a litigation that could drag on for years, does not appear to be warranted and might be a waste of taxpayers' money. Therefore, Mr. Chair, I do not intend to make any motion related to this matter at this time.
Okay. Any other questions for Ms. Hammer or Mr. Maurer? Commissioner Foster?
Mr. Maurer, would you spend a moment giving your opinion in relation to this, sir?
Let's do it this way. If you have a specific question for him, then I would invite you to ask that question.
Mr. Maurer, would you provide us with a rationale as to why you submitted this letter, this cease and desist letter?
Mr. Chairman, members of the board, my name is Frederick Maurer.
Could you speak into the microphone, please?
Sorry.
Thank you.
Mr. Chairman, members of the board, my name is Frederick Maurer. I'm an attorney in Albuquerque, and I represent the Albuquerque Police Officers Association. To answer Member Foster's question, the rationale behind the letter was upon our discovery of the extent of the letters being written, and I think that letter explains which contract provision I'm referring to. We believe that that was a violation of the contract. A question had been raised whether or not the contract was still valid. I would direct the Commission to review a case that has been issued by the Court of Appeals in the State of New Mexico on April 17, 2013, on the AFSCME case versus the City of Albuquerque and an appeal from Clay Campbell. That decision discusses the impact of evergreen clauses on collective bargaining negotiations and provisions of collective bargaining agreements. The decision by Judge Fry was that with respect to the LMRO embodies the same types of concepts that would be covered under PIBA, which has a specific provision, 10-7E-18D, 2003, which is called an evergreen clause, which provides that any time a contract technically expires, its conditions and terms stay in effect until a successor agreement has been negotiated. Judge Fry ruled that as an initial matter, while the evergreen provision of the PIBA law may not be applicable to the LMRO, the idea is applicable to the LMRO. Quote unquote, the LMRO does not permit the city to unilaterally impose conditions of employment once a CBA has expired. Instead, the LMRO includes provisions for impasse resolutions through mediation and voluntary binding arbitration. These provisions ensure the unions are participants in determination of employment conditions even after the CBA has expired. Based upon that decision, and in fact there are such mediation provisions in the contract and the LMRO, the court's interpretation was that the provisions in effect do the same process. Based upon that concept, it is the union's position that the contract, even though technically expired, is still enforceable. Provision in the contract speaks directly to this provision, and we ask that the IRO please stop doing that. The contract isn't enforced, and in fact, as you've seen in the paper, there's a vote coming on whether it's going to be renewed with new provisions, and that's the basis of the union's position.
Thank you, sir. Are there any other questions for Mr. Maurer?
Thank you, Mal.
Commissioner Siegel.
I have a question either for Mr. Maurer or Robin Hammer, our IRO. The letter which we have received, is this privileged document, or is this something that can be put on our website so that the public can understand the changed conditions under which we are receiving CPCs from here forward? And the question really is twofold. IRO Hammer's letter to us and Mr. Maurer's letter to, I have it here, to Ms. Hammer, to IRO Hammer.
I will answer for myself and only myself. I think Ms. Hammer is more than qualified to speak for herself, but I would clearly state that my letter to Ms. Hammer, which has been turned over to this board, is not privileged communication in any way.
Okay, thank you.
Ms. Hammer, do you have an answer for Commissioner Siegel?
It is a public record, the letter itself.
Okay, Mr. Chairman, in that case, I would ask the Commission's concurrence in requesting Ms. Hammer publish her letter to us, dear Commissioners, dated December 3rd, and Mr. Maurer's letter to her with its attachments on the POC website so that the public can better understand the framework in which we are receiving CPCs and what's in them and what's not.
Is there a second to the motion? Commissioner Barella seconds. Is there discussion?
Sure.
Commissioner Foster.
I don't understand why we're making a motion. If this is a public document, then this is a document that we can place up on the website without us concurring.
Well, and I would also point out that it's the IRO's website on which the POC has this information is put onto it. It's not the POC's website. I want to make that clarification.
Okay. So then I guess the instead of a motion, perhaps there is a request that these letters be put on the website.
Point of order, Mr. Chair. I think there's a motion and a second on the floor, and I think we should vote on it.
I would submit that under the city attorney's interpretation that the POC cannot order the IRO to do anything, that I would that it would be my discussion of the motion that it would not be appropriate under the Mr. Turk's interpretation of the ordinance.
So I rule that the motion was out of order. So therefore, the second is out of order as well. And so, Commissioner Siegel, would you like to request of the IRO to place these letters on on the IRO's website?
I would, and let me clarify that when I initially made the request, I did not make a motion. I asked the POC's concurrence. You asked for a second in that. I had not considered it to be a motion. I was asking for our concurrence as a request to the IRO that she post these as a matter of public information, and that remains my request as a request. So I'm asking
Okay.
for a sense of the commission.
Not a formal vote, then. Is there anyone who has any objection to these letters being placed on the IRO's website? Hearing none, then would you like to make your request of the IRO?
So I do request that on the public's behalf, both these be posted to the website, including any attachments that were made. Incidentally, the letter we received from Mr. Maurer showed a fax of 4 pages, but in fact I only received 3 of them, pages 1, 2, and 4. So if there's a third missing page, try and be sure that that's attached to as a part of that document, if you're willing to put it up. Thank you.
Any other questions of Ms. Hammer? Okay. Commissioner Foster.
IRO. It came in front of us here earlier about our web page to the public. I'm receiving emails. Do we have the web page up, or do we not have the web page up?
There is an email in response to the lawsuit that was filed against the POC and individual members, some individual members. It's the settlement of that lawsuit included an agreement by the city to have one email in which all members of the public could email the members of the POC. And that email is on the website, the IRO's website, under the POC Commissioner tab. If you want to contact the commissioners, you go to that website, and to that portion of the website, and the email address is there. It's poc@cbq.gov. From that, an email is sent to all members of the commission. On that section of the website, there is the caution that the POC cannot give legal advice, that contacting a POC member about a pending case would jeopardize that POC's members' ability to sit on a case, so members are strongly discouraged from doing that, but there's nothing that, under the terms, that there's no screening process for what goes into that email address.
Okay. Thank you, Ms. Hammer, for your report.